A warm welcome from the heart of Munich at the Data Protection Café. Today's topic is the ability to issue warnings for GDPR violations. Are competitors allowed to issue warnings for GDPR violations by other companies? Learn more in today's video. The question arises whether GDPR violations can be sanctioned not only by the supervisory authority, but also whether competitors have the possibility to pursue such violations through the legal remedies provided in competition law, particularly warnings. What does the Unfair Competition Act state? It is also displayed here that it is impermissible to violate a legal provision that serves to regulate market behavior if this violation significantly impairs the well-being of market participants or competitors. There is, as you might not be surprised to hear, also legal uncertainty regarding this matter at present. The Federal Court of Justice has referred key questions on these aspects to the ECJ in a current case. So let's take a closer look. The Unfair Competition Act states that it is prohibited to violate market rules if this affects other market participants. Recently, the District Court of Düsseldorf also ruled that violations of the GDPR can be warned under the Unfair Competition Act. Link to the ruling below in the description. This means that there are indeed voices in the courts that qualify the GDPR as a law that can be subject to warnings. Incidentally, the Advocate General of the ECJ argues along the same lines. The decision of the ECJ itself is still pending. The Advocate General also states that, in his opinion, it would not be contrary to the GDPR if national regulations were to complement it, allowing competitors to issue warnings for GDPR violations. According to the Advocate General, warnings cannot be issued directly from the GDPR itself. Therefore, it always requires national support through corresponding competition law. Bavaria is now also taking a similar stance. Bavaria has introduced an initiative in the Federal Council, which has now been taken up by the Federal Council, to legally stipulate that GDPR violations cannot be warned under the Unfair Competition Act. According to the Bavarian Minister of Justice, the background is that a right for competitors to issue warnings for data protection violations under competition law is not required by the GDPR and carries particular potential for abuse, and thus economic risks. One can see here the risk that the ECJ might follow the Advocate General, who could clarify that the Unfair Competition Act permits warnings under the GDPR and wants to mitigate this risk in advance. To close with von Ebner-Eschenbach. A judgment can be refuted, but never a prejudice. And with that, the courts in Germany have so far assessed inconsistently whether GDPR violations can be warned under the Unfair Competition Act. A case referred to the ECJ by the Federal Court of Justice regarding these aspects is still pending. The Advocate General says, GDPR violations can generally be warned if they are supported by national law. This is precisely what a Federal Council initiative is now attempting to address, requesting the Federal Council to amend the Unfair Competition Act so that GDPR violations are explicitly excluded from warnings. What else has happened in data protection? Our colleague Jens Ferner takes a deeper look at the consequences of a hacker attack in light of the current ECJ jurisprudence in a blog post. Link in the description. Enjoy reading.